Today I'm going to be talking to you about what happens in a DUI traffic stop in DC. Now at the outset, it's important to know that the best way to avoid a DUI conviction is to not drink and drive in the first place. I always tell clients that even a $200 Uber ride home is going to be far less costly than getting arrested for a DUI in the District of Columbia. That said, our firm has represented hundreds of clients for DUI, and we've seen the police arrest folks who were not under the influence, and prosecutors charge them anyways. Now, there are lots of reasons police do this, and while as a society we have greatly reduced the number of DUI fatalities and accidents by imposing strict DUI laws, lots of law-abiding citizens have gotten caught up in the arrest process even when they haven't been under the influence. Now, an example I like to give is a colleague of mine who had a client who had been arrested and blew a 0.0 at the police station. The police were convinced that the person was instead under the influence of drugs, and so they had the person take a urine test at the station, and the prosecutors charged them for DUI in DC. My colleague went to the prosecutor to ask them to dismiss the case, again, because the client had blown a 0.0. And the prosecutor said, well, the officers think that the person driving was under the influence of drugs. So we need to wait to see what the urine results come back with. And getting urine test results back in DC in a DUI case can take about 3 months. So when the prosecutor got the results, they came back with no drugs in the person's system. So my colleague again goes to the prosecutor to dismiss the case. And the prosecutor said, well, I spoke to the officer and he believes that your client was under the influence of inhalants, which wouldn't show up in a urine test in the first place. You cannot make this stuff up. This is often how folks are treated in the criminal justice system, especially when it comes to DUI arrests. There is absolutely no question that police often mistake a random or strange or otherwise different behaviors for evidence of intoxication, even when there are perfectly good explanations for the behavior. Now, I've had cases where a client was too talkative, and the police put in the report the suspect was too talkative, and they must have clearly been under the influence because they talk so much. In other cases, I've had police claim that someone was being too quiet, and that was a sign of impairment. I kid you not, in one case, the government first tried to claim that my client was swaying because police wrote in the report, client was swaying. Then when the body-worn camera evidence revealed that the client was standing perfectly still and straight for a long period of time, the prosecutors then claimed that standing up so straight for such a long period of time was a clear sign of being guilty because the person was just trying too hard to stand still. Again, you cannot make this stuff up, and lots of law-abiding citizens get caught up in this stuff. So by the end of this video, you will understand exactly what to expect if a police officer pulls you over in DC and suspects you are driving under the influence of alcohol or drugs. So what happens when officers make a DUI arrest or traffic stop? Keep in mind that all stops may be different, but they are generally going to follow the same playbook, which is what they're trained on, is this manual. It's the National Highway Traffic Safety Administration publication, DWI detection and standardized field sobriety testing. Officers who get this training from NHTSA, or the National Highway Traffic Safety Administration, must complete a course based on this training manual to become a DUI certified officer. Now, at Scrofano Law PC, all of our lawyers, myself included, have taken this same course. It's a 3-day course and gotten the same training and certificate as most of the DUI officers in the city have taken as well. Now, on top of that, we have collectively watched thousands of hours of body-worn camera footage over the years in hundreds of DUI cases and have seen a lot of the same things in the body-worn camera footage. So the first thing the officer observes when is what NHTSA calls stage 1 in DUI detection, vehicle in motion. There are a number of clues an officer looks at when deciding whether to effectuate a DUI traffic stop. But the reality is they can be any traffic infraction: speeding, swerving, weaving, driving down the wrong way in a one-way street, rolling a stop sign, not using your blinker to pull out of a parking spot. Pretty much anything you can get pulled over for can lead to a DUI traffic stop. Now, the next phase is called personal observation. The officer will approach the vehicle and get you to roll your window down, ask for your license, ask for your registration, and here the officer is going to rely on her physical senses to try and observe whether they think you're impaired. They're going to ask themselves, do you smell of an odor of alcohol? Is there an odor of alcohol emanating from the vehicle or from the driver's breath? Did the driver speak with slurred speech? Or my favorite is what they'll write in the report is that the driver spoke with a thick tongue, whatever that is. This is likely where they'll ask you if you had anything to drink tonight. Here's a tip. If you say you only had 2 drinks, they will 100% believe that you're lying and intoxicated. Why? Because that's what everyone says. People have a tendency to believe that if they're honest with the officer or partially honest and admit to drinking a little but not to how much they actually drank, it'll somehow make their story more convincing and make it less likely that the officer is going to arrest them. Take it from me, that is the worst possible thing you can say. And it's really worse if you actually have had only 2 drinks because they're going to assume you're lying. Now, sometimes they'll ask you questions about where you're going or where you came from. For those types of questions, they're mostly trying to get you to talk so that they can further observe whether you exhibit any so-called cues of impairment. The officer will watch how you retrieve your license and insurance. Do you fumble around when you get your wallet and you're trying to get your license and insurance out of it? They're going to be looking at your eyes. Are your eyes bloodshot or watery? Do you make any weird statements? Do they smell any strange odors? Now, if the officer feels that they've observed enough cues in the personal observation phase to have a reasonable suspicion that you're driving or operating the vehicle under the influence, they'll then ask you to step outside of the vehicle for phase 3, which is called pre-arrest screening. Keep in mind, however, they will be observing you as you exit the vehicle. Do you stumble on your way out of the car? Do you use the door to pull yourself up? Do you appear to have to lean on the vehicle to stand up? They're usually going to ask you to walk over to a sidewalk or some other nearby area to safely perform the standardized field sobriety test. And you can bet that they're observing how you walk to the sidewalk. Do you sway or lose balance as you're walking over to a more well-lit area? So pre-arrest screening consists of 3 standardized field sobriety tests. With each test come with a set of cues that only the arresting officer gets to decide whether you exhibit them or not in order to make an arrest. These 3 standardized tests are called the horizontal gaze nystagmus test, the walk and turn test, and the one-leg stand test. And I'm going to talk about each one in turn. First, the horizontal gaze nystagmus, or Hgn test, is something most people probably recognize, maybe you've seen on TV. It's where they have you follow a pen or some type of stimulus with your eyes. You know, there are a lot of misconceptions about this test. Most people think the whole test is whether you move your head or move your eyes as instructed. A lot of people think that if you move your head, that means you fail it. That's totally false. They're looking for something completely different. The Hgn test is basically a ridiculous voodoo science that says if you're under the influence of alcohol, your eyes are going to exhibit certain jerking movements when following a stimulus. And this test consists of 6 cues the officer is looking for, 3 in each eye. The first cue is a lack of smooth pursuit in each eye. The officer is checking to see if your eyes track smoothly or if they jerk as they move across. So you're moving your eyes like this, and think about it as a visual think about a visual as a functioning windshield wiper on a car versus a broken windshield wiper that sort of scrapes across the windshield. They're looking to see if your eyes are sort of scraping like that. The second two cues are distinct and sustained nystagmus at maximum deviation. At that point, you're basically holding the stimulus out as far to one side at a maximum deviation for 4 solid seconds on each side to see if your eyes bounce or jerk in a distinct and sustained way when they're forced to look out to the side like that. Finally, the last two cues in the Hgn are onset of nystagmus prior to 45 degrees. Here the officer will move the stimulus very slowly until it gets to a 45-degree angle from your eye, and they're looking to see if your eyes start to jerk before it gets to the 45-degree angle. And as you can imagine, this test is extremely subjective, and it's up to the arresting officer completely to determine whether they see these cues or these jerking movements in your eyes or not. You can't see what your eyes are doing. And if you exhibit 4 of the 6 cues, then NHTSA trains the officer to believe that there is probable cause to make an arrest for DUI. Now, it's particularly a problem because, again, you can't see what your eyes are doing. Only they're looking at it. Now, the second test is the walk-in turn test. This is like what you've seen on TV where they'll have you walk a line 9 steps, heel to toe, turn in a distinct way, and walk back on the same line 9 steps, heel to toe. Here, officers are looking for 8 potential cues of impairment. The first one is if the subject cannot keep his or her balance while listening to the instructions. So here the officer is going to make you sort of stand in an awkward position and expect you to hold that position the entire time as he explains the instructions. And if you break from that position, then that's a cue. And sometimes the officer will tell you, sometimes they won't. The second cue is if the subject begins before the instructions are finished. So sometimes the officer will start to give instructions, and if the person starts walking before they're finished, while the officer's still explaining the instructions, then that's the second cue on the walk and turn test. Third one, the subject stops while walking to regain balance. That's if you're walking any of the 18 total steps you have to take. If you stop during any of those 18 steps, that's a cue. The subject does not touch heel to toe. That's an obvious one. If you don't touch heel to toe on any of the 18 steps, that's a cue. That's only one cue though. So if you don't touch heel to toe on all 18 steps, it's still only one cue. Another one is the subject steps off the line. If you step off the line while you're doing the 18 steps, that's a cue. Now this one is particularly ridiculous because oftentimes if there's no readily available line on the ground, like a sidewalk, like a line on the sidewalk, the officer will tell you to walk on an imaginary line. So they're judging you on whether you step off of an imaginary line. Another one is if the subject uses their arms to balance. So if you raise your arms while you're walking the 18 steps, that's considered a cue under the walk and turn test. Another one, the subject makes an improper turn. Now the officer will demonstrate how to turn at the end of the 9 steps by taking a series of small steps to do this turn. And if you do it the way the officer demonstrates, then you're fine, but if you don't, then it's a cue. That's another cue of impairment. But guess what? Oftentimes the officers are going to demonstrate it incorrectly, and then when you do it incorrectly, they'll ding you on that one as well. Another one, the subject takes an incorrect number of steps. So if you take more than 9 steps back and more than 9 steps back, coming back, that's a cue. So if you go 10 steps or 7 steps and then you turn, that's a cue. The final test is the one-leg stand test. During the one-leg stand test, the police officer will instruct the person suspected of driving under the influence to hold one leg 6 inches above the ground and to count out loud. 1, 1,000, 2, 1,000. The officer is instructing the person to count and won't tell them that the officer is timing for 30 seconds while they count 1, 1,000, 2, 1,000. They're usually not going to inform the person how long to count in advance. And like the Hgn and the walk and turn, the officer is looking for specific cues of impairment for the one-leg stand. The 4 cues are 1, The suspect sways while balancing. So if you sway when you're trying to balance, that's a cue. 2, if the suspect uses their arms to balance. If you raise your arms, that's a cue. If the subject hops to maintain balance is number 3. And then finally, if the suspect puts the foot down during the 30 seconds while their one leg is being held. That's a cue as well. Now, in future videos, I'll go into more detail about the SFSTs, but for now, it's important to understand that if an officer suspects that you're driving under the influence, they will follow a pretty standard playbook. And the truth is, if the officer asks you to step outside the vehicle, it's very likely they have already made up their mind to arrest you. Very few people pass the SFSTs and are able to convince the officer not to arrest them. Why? Because these tests are designed for you to fail and the officer to make the arrest anyway. Now, if you want to find out more information, click on the link in the description below. Getting arrested for a DUI can be very serious. If you or a friend or a family member have been arrested for a DUI in DC, Maryland, or Virginia, contact us today for a free case evaluation.